it is going. So next speaker we have is Miss Wijeratna. She will be speaking to you all on entering a contract at will, a critical analysis of the principles governing duress. I think this is a very interesting area because I always say the banking industry is totally dependent on the law of contract. So therefore, this concept of duress, I know she will do justice to this topic. To you, Ms. Wijeratna.
Thank you very much, Honorable Chairperson. Good morning, ladies and gentlemen. I can see how exhaustive you are from listening to our intellectual conversations from morning onwards. So I'll try to keep my presentation very brief and simple. My research involves an in-depth analysis of the principles governing the doctrine of duress in contract law. Sorry for the inconvenience. First of all, I would like to draw your attention to the element of free will in contract law. A contract, as we all are aware, is an agreement which produces legally binding obligations. For the purpose of forming a valid contract, the parties to this contract must enter into it with a free will. The doctrine of duress, on which my research is based upon, can be identified as a vitiating element, if present, which will make the contract voidable. When a contract is voidable, it is valid unless the parties to the contract repudiates it. As you can see, the factor which distinguishes contractual obligation from other legal obligation is that they are based on the agreement of the contracting parties. The doctrine of duress involves cases where a person enters into a contract as a result of coercion. What permits interference of courts in such circumstances is the fact that it violates a fundamental principle of contract law, the free will. When a contract is stimulated by a method which is unlawful, the court does not allow such contract to stand. Existence of a threat, veiled or actual, is a mandatory requirement for duress. In cases where duress is present, person or persons whose rights are infringed acts in a manner that he or they would not have in normal circumstances. The objective of my research is distinguishing the area under the doctrine of duress, which need clearer exposition. And if I talk about the methodology, I basically followed the black letter approach and I highly depended on case law. They are the primary sources, and the other secondary sources involved books with critical analysis, journal articles and web sources and conference papers. In very early stages, this doctrine of duress was quite narrowly interpreted. Then equity formulated a new concept called undue influence in order to fill the gaps in law and this undue influence doctrine has a wider scope or ambit. Now some are of the view that these two concepts cannot be segregated. In fact, Mexican Supreme Court in one decision, Strick versus Strick, expressed opinion that it's impossible to mark an accurate line where one doctrine starts and the other ends. As I mentioned earlier, this doctrine of Duress was very narrowly interpreted in early stages. In the early stages of English law, it actually referred only to a physical violence or a threat of physical violence to the person of a contracting party. Then over the time, however, the ambit of this doctrine was developed to deal with duress to goods and economic duress as well. What we have to note in this context is the fact that this development led to confusions in law. Initially in 1976, in Occidental Worldwide Investment Corporation versus Kipps decision, illegitimate business compulsions which pose an adverse effect on the financial eudaimonia of a person was accepted as one of the grounds based on which a contract can be vitiated. However, what we should notice is the ambiguities in relation to the area of economic duress also was aggravated with this development. It is noteworthy that most of the time duress and the economic pressure overlaps. As specified by Lord Diplock in one instance, commercial pressure in some degree exists whenever one party to a commercial transaction is in a stronger bargaining position than the other party. Judges over time have expressed different opinion about considering commercial pressure as duress. In Power On versus Loy Long case, judges stated commercial pressure cannot be considered as duress in the absence of vitiation of consent. However, over the time, the element of vitiation of consent was replaced by the element of absence of choice. It's noteworthy that judges in Power case recognized the possibility of considering commercial pressure short of duress as a basis for repudiating a contract. And also they identified this issue as a matter of question of degree and fact. This made the law more confusing and inexact. In this context, it's important and crucial to distinguish legitimate and illegitimate pressure. In one case decided in 2007, Justice Donaldson states, the elements to be given consideration when determining whether the pressure exercised in a case is legitimate or not are not well settled and not exhaustive. He further stated that making a value judgment is unavoidable, and when deciding whether the exerted pressure has exceeded the limits of common law and general commercial pressure. However, what makes law more inexact and ambiguous is the fact that sometimes lawful act can amount to illegitimate commercial pressure. Therefore, it's clear that although the concept of economic duress is well defined in general terms, the parameters of the concept is remained unclear and unsettled. When it comes to economic duress, when it comes to proving of duress, as elaborated by Lords Carman in Universe Stanship case, two elements are to be established, namely illegitimacy of the pressure and compulsion of the will. Compulsion of the will indicates absence of choice, which makes the coerced party run out of any other option than to comply with the demand. The cases decided so far do not provide a clear picture with regard to the proof of economic duress. When deciding whether there is an absence of choice, so far no specific criteria has been established. and it is completely left to the discretion of the individual judge. However, in the absence of a clear standard or at least some precise set of guidelines, judicial decisions continues to lack consistency and thereby fail to provide the required certainty in the area. Therefore, the doctrine is indeterminate and it's also have to be applied in the light of varying circumstances of each individual case. This results in having countless contributing factors to be subjected to consideration when offering a remedy. I would like to put forward several recommendations. When distinguishing legitimacy and illegitimacy of pressure, developing a scientific criteria to measure internal consent is actually impractical. However, developing clear guidelines to consider when examining the exterior criteria can be a practical option. The operation of solely intuitive justice when deciding the relevancy of factors is risky. Rather, a comprehensive, articulated set of principles should be developed. Limits of the doctrine of economic duress are determined principally based on policy grounds. So, therefore, the value judgment cannot be completely avoided. But I recommend, for the benefit of the cases that might arise in the future, a clear set of guidelines, although might not be exhaustive, should be developed by the courts. Similar to the ambiguity existing in some areas of economic duress, in cases of duress to goods, no precise guidelines exist. What can be merely stated is that if a set remedy is to be established by law, in relation to duress to goods, it should be narrower and must be based upon much more limited basis than in cases which involve duress to person. Therefore, it's recommended that a proper guideline authority should be developed to decide the foundation depending on what a remedy would be permitted. Another major difficulty that exists in this area is lack of awareness among laymen with regard to these fundamental concepts of law of contract. Due to ambiguity and complex nature of the law, one might enter into a contract without, as a result of duress, and not knowing what remedies the law will provide them. Therefore, it is recommended that these doctrines and standards which promote contractual free will should be enclosed in Code of Business Conducts and Ethics as far as possible. Compared to economic duress and duress to goods, the traditional concept of duress to persons are more straightforward. The concept of economic duress lacks well-defined and set parameters. The contemporary legal framework regarding the doctrine is not free from ambiguities, and it is solely based on intuitive justice. In the same manner, the doctrine of duress to goods has in its scope ambiguous areas as well. So, following my research, it can be concluded that although economic duress and duress to goods are well defined in general terms, although they are strongly established in law, they demand a clearer interpretation and proper guidelines, precise at least to some extent in unclear areas of the doctrine. Thank you very much.
Thank you, Ms. Wijeratna, for the excellent presentation you made. Let me make a few observations from a practitioner's point of view. I think one of the reasons why this area of law has not developed in this country, the economic duress and the duress to goods, both these things happen with regard to commercial activities. Most of the time, both these things happen with regard to commercial activities. And the person who is affected by the person who is affected by this duress is not in a position to retain the best possible counsel to fight his case out. That is why this country, this law is not developing. I have seen this. I have been always telling, I have been being a banker, I have been on the other side of the coin, I have been with the banks, I have been always advising the banks to say, it's a matter of time. The tactics, the methodology that you all are using in getting documents signed, the way that things are been happening, will quickly make a change as soon as the consumer knows what his rights are. The day that the consumers get together and set up their own association to fight back against the establishments, this area of the law will develop, and people like you will be in big demand by the consumer protectors to fight their cases. Thank you for the presentation. So next